Hello, welcome. Happy Friday to everyone. I am Liz Mulroy. I'm the Senior Director of Mission Delivery for the National Scleroderma Foundation, and we're happy that you all can join us today. We have a really great speaker and her assistant here today. I'm going to let Catherine actually introduce them. But first of all, let me introduce Catherine Rebert. Catherine is part of the Tri-State chapter, and she has been involved with the chapter for over 16 years. She is a part of the support group in Rochester, and she is also on the chapter advisory committee. She has been on the education piece of that committee for about 1 year. And so she has offered this session today, and I'm going to let her kick it off and introduce our speakers. Thank you, Catherine.
Good afternoon, everyone. We're so excited to welcome you to this webinar on the importance of estate planning. My name, as Liz said, is Catherine Rebert, and I serve on the Education Committee for the Tri-State Clinical Advisory Committee. And I really feel that this topic is of great importance to our scleroderma community, and I'm so glad that we could help provide this education to you. I have the pleasure of introducing you to our speaker, Dedra, or Dee as she likes to be called, Sibley, a personal family lawyer who will be providing her expert guidance on the topic of estate planning. She has a short introduction video about her extensive background and services, followed by a very useful and valuable presentation on her topic. If you have any questions, please feel free to put them in the chat. And during our Q&A segment immediately following the presentation, they will be addressed. And now I am delighted to introduce to you Dee Sibley.
Thank you, Catherine. Thank you, Liz. Thank you for the opportunity to come today. So I'm going to share my screen so that we can jump right into the most important matters at hand. So give me a moment. Let me transition over here. And if Brittany, you can give me a thumbs up when you can see my screen. That would be perfect. Thank you. Thank you. All right, you all. So let's jump in and talk about some really important stuff here. And as Catherine mentioned, I'll do a quick introduction, but I'll do that along the way. So let's jump in. We're going to talk about estate planning. I like to say planning for life, building for legacy. And you'll learn a little bit about why I say that. So as we move forward, I'm going to show you a very short video that talks about who I am and why I care about this ever so important topic. So let's get started. Sibley Law & Associates is based upon legacy. And I take that seriously because I want for you and your family what I would want for me and my family. When I'm sitting down with you and we're talking about family and what your goals are, I'm also reflecting on what it means to me. I design plans that I would want for myself when I'm working with you. So we're looking at all the scenarios, the what ifs. We're trying to address everything to make sure that when you walk out that door, you're comfortable and you feel like you have done the best that you want to do for your family at that time. My name is Dedra Sibley. I go by Dee, and I am the managing attorney at Sibley Law & Associates. I've been practicing law now for about 16 years. I have done criminal defense. I have done labor and employment law. I've done a lot of what we call consumer law, which is landlord-tenant, foreclosure defense, things like that. And my passion lies with estate planning because I had an initial reflection when my grandmother passed away when I was a young girl, and she had wanted me to have a pearl set that my dad had sent to her when he was in Vietnam. She'd always told me that I would get that when she passed on, and it didn't happen. And it really devastated me because I knew that she wanted that for me. It really intrigued me how a process could go so wrong. And so I wanted to help other families to really leave their legacies the way that they want to. I take complex legal strategies and I make them simple so that I can partner with my clients to develop their wills and trusts for their estate plans to make sure that their legacy is in place for their loved ones. We really offer different levels so that families can grow into those resources. So you can start at one level, and over time, as your resources build and change, as your family structure change, you can move to the next level and add those additional levels of protection and security for your family. So one of the ways that we are different is that we create a family legacy interview. So imagine the grandparents who have created this video so that their grandchildren, long after they're gone, are able to see and hear their grandparents. Imagine the new parents who are coming in to do the estate plan while mom is still pregnant, and they're creating this video before the child is even born, talking about how much they're looking forward to the birth of this child. And in that process, they've already started to plan their life for their young one. So we create an environment where it's not just doing the documents, but it's also starting to create and build that legacy. If you're nervous or scared about having that conversation, about looking into estate planning, or if you already have an estate plan done and you want to make sure that it's still up to date and it meets the needs of your family, I invite you to visit our website or give us a call at 321-844-8694. I would love to partner with you to make sure that the legacy you're leaving is one that you want for your family.
Okay, so let's jump right in here and keep going. Nope, for some reason, and you're still able to see my screen. Okay, so let's see. All right, so what we're going to talk about today is what is estate planning and kind of define for you probate. We'll talk about a will-based estate plan, a trust-based plan. I'm going to give you some key takeaways, and if you don't want to do either or neither of those key takeaways will give you some action items that you can do tomorrow or Monday when the banks and those kind of institutions open. So either way, you can walk away with a short little checklist of some things that you can do immediately. All right, so I get the question all the time, well, who is estate planning for and why is it important? So I want to address that. I do want to let you know that this webinar is not intended for you to walk away and know everything there is about estate planning. There's way too much information. Estate planning, as you will see, is a very personalized process, but my goal for you is to have at least a basic understanding of estate planning and to be introduced to some of the terms so that when you hear it, for instance, a revocable living trust, what is probate, those kind of things, that you'll have some frame of reference, okay? But this is just the foundation we're going to be talking about. So who is it for? Estate planning is for those parents who want to make sure that their kids are protected and the inheritance that they may be leaving for their children is also protected. It's for anyone who wants their family, their loved ones, to avoid those court battles later on in life. It's for those that want to have some control over your legacy. And I challenge you to define legacy for you. There is no one definition of legacy, but what legacy is not is only about the documents that you leave in place. Your life, your well-being is so much more than just those documents, which is one of the things that I built my firm on, is building that holistic view of your legacy. But it's also about anyone who wants to create peace of mind. They want to know that they have taken the actions to make sure that they're taken care of, as well as their loved ones are taken care of. So our first question throughout this, I'll challenge you to put a couple things in the chat. And Brittany, one of my assistants in the office, my client services director, is going to help us to kind of monitor that. put in the chat, if you will, what does estate planning mean for you? Just thinking about what is a definition of estate planning. I'm always interested in how people are defining estate planning. And so we'll take a look at that as we go throughout. All right. So another question that we get all the time is, well, at what stage should I be doing estate planning? Am I too young to start estate planning? Have I passed the best opportunity for estate planning? Am I somewhere in between? And I say probably all of that. Estate planning is relevant for anyone that's 18 and over. So if you're 17 and a half, almost there. If you're 18 plus, you're there. And the reason I say that is because at the age of 18, you are considered an adult, meaning you are legally entitled to make those decisions for yourself. Mom and dad can no longer step in and say, here's what I want to have happen and how I want it to have happen. Now, I have 2 adult sons and 5 grandchildren. My oldest grandchild is 16. But I can remember when my sons went off to college and they were over the age of 18, of course. And I can remember calling the college at one point and wanting to get the grades and find out how they were doing and check up on them. And you know what the administrator told me on the other end of that phone? I'm sorry, Mrs. Sibley, I cannot give you that information. Dennis has to authorize for me to even talk to you about any of that information. I was astounded. Even as an attorney, I'm like, really? I'm paying the tuition. I'm taking care of all the expenses, and you can't share with me his grades or how he's doing? None of that. So I want you to remember at the age of 18, parents, grandparents, aunts, uncles, loved ones, you do not have a legal right to demand any of that information unless that young adult has given you permission. And at no age are you certainly over the age where estate planning can be relevant. So estate planning is for anyone 18 and over. Now, what I will tell you is there's different levels of estate planning. So depending on your age, depending on your circumstances, depending on your family, it's not a one size fits all. There may be some things that's appropriate for a young college graduate that may not be needed, or more that's needed for an older adult. So think about 18 and over is our answer. So when we're talking about estate planning, what exactly are we talking about here? For the purposes of this presentation, we're going to be looking at incapacity, disability, and eventual death. Incapacity meaning, in the legal sense, when the law says you're not at the mental ability or physical ability to be able to make decisions on your own. So you need some support in some way. Disability, oftentimes we're referring to those physical inabilities to do those things on your own. You need some physical support with your daily living, your daily bodily functions. And then, of course, passing on death. So estate planning can mean peace of mind, planning for those periods of time when you may need some assistance yourself or when you have passed on, making sure that you're leaving things the way that's most important for you. When I speak to people, I like to drop what I call some nuggets of information, because one of the things that I've learned over the years doing this is that there's a lot of misinformation about this area. So I like to provide a little bit of those debunking some of those myths. And one of those myths is that the estate planning is a one and done kind of event. You're going to see that that is not applicable. Part of estate planning is, I like to say, it's 50% about taking care of yourself, and it's 50% about taking care of your loved ones when you're no longer here. Quite often, people think of estate planning as only passing your assets when you're not here anymore. But I want to help reframe that thinking. If you've ever been on an airplane and before the flight even takes off, leave the runway, what does the flight attendant say to us? They say, in the event of an emergency and that oxygen mask comes down, anybody put in the chat, what do they tell us to do? Brittany, if you see anyone put the answer in there, I'd love to hear it. I'm going to give you a second before I spill the beans.
Nothing yet.
Okay. All right. I'm going to give you this freebie. Oh,
And one
do we
second,
have an answer?
I'm going to actually chime in real quick. If you're having trouble with the chat, go ahead and use the Q&A box at the bottom of the screen. If you don't see that, go to your More button and you'll see Q&A listed under More and type your answers in Q&A. Thank you.
Thank you, Liz. Thank you. Okay.
And they're pouring in.
They're pouring in. All right. So maybe we'll see how many people have the right answer. That attendant says, in the event of an emergency and the mask comes down from the ceiling, first put the mask on yourself and then assist those that are with you that need help. So same guidance here. For estate planning, it's about taking care of yourself first while you have mental capacity and you are alive. That's when your opportunity to make those decisions and put those plans in place. Because at the point of incapacity, you can no longer do that. Is now going to the court to make those decisions for you if you don't do it yourself. So same concept with estate planning. It's about taking care of yourself first and then assisting your loved ones and providing for them. So let's get started. It's about you and your loved ones, you being first. All right. So we do know that part of estate planning is planning for death, right? It is talking about, thinking about, planning for what will work when your family needs it, when you're no longer here and able to make those decisions or provide that support. What have you done in advance to help ease in that transition, to help make sure that your family can stay out of court and conflict as much as possible, to make sure that probate and estate taxes are minimized for your family and your loved ones? When you're no longer able to provide that legal, financial, emotional support, how is that going to be addressed? And to make sure that none or minimal of your assets are lost to the state. So that's part of estate planning. But as I mentioned, the other part is planning for your life, planning for while you're here. And I'm going to walk you through some scenarios and give you some real life examples of how that comes into play. All right, so going right along. So let's talk about what happens when you don't do any estate planning. What does that mean? What are some of the consequences of not doing estate planning? So when there's no estate planning put in place, that means that you haven't provided any protections for your spouse that survives. There are no decisions made for your children, meaning you haven't taken on that responsibility of making sure that you have provided what's needed for them to go to the person that you want them to go to, provided that guardian listed for them. It means that your beneficiaries could lose what you leave them because there's no protections that's been put in place. For stepchildren, if you don't provide anything in an estate plan, in most states, and certainly here in Florida, where my office is located, if you don't put in plan something for your stepchildren, they are not entitled to inherit from you. Not at all. And it means that you're having no say in how you die or your last days here. And we'll talk about what that looks like, not leaving anything for organizations or charities, and not picking the person that you want to help your family or even yourself during that period of time. Another thing I'd like for you to put in the Q&A section for me is let me know if you have an estate plan in place yourself. And then on a couple slides, I'll come back and address that. But put in the chat, yes or no, do you have an estate plan? All right, so if that doing nothing means all of these kind of impacts for your loved ones, for yourself, then why don't more people do estate planning? So what you see on the screen are some of maybe the most common reasons, but I'm sure you can think of some others. But here's the ones that we hear quite often. See if any of these resonate with you. Well, I feel like I have plenty of time. I'm going to do it. I just haven't gotten to it yet, but I know that there's still more time. I say to that, maybe, maybe not. Because remember, you can do your own estate planning when you have capacity, the mental capacity under in the legal sense, and while you're living. Sometimes people will say, well, I don't have enough money to have an estate plan. Maybe, maybe not. I say, do you have a home? Do you have life insurance? Do you have a bank account? Do you have a retirement plan? Do you have any assets? And again, we're talking about legacy here, not just leaving $1 million estate. We're talking about leaving the things that are most important to you, to the ones you love the most, in the least way of conflict, and about taking care of yourself while you have the ability to make those decisions for yourself. So I don't know. Do you have enough to have an estate plan? Sometimes people will say they don't care what happens after they're gone. Maybe, maybe not. If they don't, then maybe an estate plan is not for them. But again, this webinar is about to empower you with information. It's not about convincing you to do anything. Once you have the information, you can decide what you want to do and what works. Sometimes I hear people say, well, my family knows what I want. I don't have to write it down. Well, in my video, I talked about everyone knew I was supposed to get the pearls that my dad sent to my grandmother when he was in Vietnam because I'm his oldest daughter. But that didn't happen. And I see it all the time. If it's not written down, if it's not prepared in a legal way, it can lead to conflict. It's not a priority, or if you feel like your family is going to lose it anyway. So do any of those reasons resonate with you? Are any of those reasons things that are holding you back from doing estate planning? It's a personal question. Brittany, did we get any responses on how many people may have an estate plan already?
Yes, actually a few. One person said no, another person said yes, another person said no, and then so it's pretty much two and two. Two yeses and
Okay.
two nos.
Okay. So I have some good news and some bad news for everyone on this webinar today. Okay. And normally what I would say is, do you want the good news first or the bad news first? But I'll go ahead and give you, I'll start with the bad news so we can end on a positive note. The bad news is you may not want it. You may not want it. But the good news is everyone on this webinar has an estate plan already. So if you said yes, you are correct. If you said no, the good news is you actually do have an estate plan. But the bad news is if you don't put one in place yourself, meaning you took the action to put one in place, then you have the one that the state, whatever state you're living in, they have given you one. So you have one. Either you did it yourself or you're going to use the one that the state has given you, whether you want it or not. If you don't want it, then you have to put one in place yourself. But we all have one. Now, I have one that I put in place because I wanted to make sure that my wishes, my husband and I want to make sure that we have done some things for our family. But either way, you do have one. All right, so what you see on the screen is a list of people, and you probably recognize most of these names on the screen. You want to drop in there, what do they have in common? What do all these people have in common? I know what the typical responses are when I put this on there, but anyone want to put in the Q&A what do they have in common before I tell you? Brittany, you can jump in.
There are a bunch of different answers. We have rich and famous, estates, lots of money. Some, one person said died without a will, untimely death, no estate plan,
Awesome.
had
Awesome.
estate fighting, and then one person said deceased. So all
So it's
correct-ish answers.
yeah, well, yeah, all correct. They're all deceased for sure. Now, in terms of an estate plan, we already know because I just said they had an estate plan, whether they had the one that they put in place or the one that the state gave them. So everyone here, with the exception of Elvis Presley and Kobe Bryant, went for the estate plan that the state gave them, meaning they did no formal estate planning themselves. So the question becomes, well, why do I have Kobe Bryant and Elvis Presley on this list then? Well, remember when Kobe Bryant, when that plane went down that fateful day, he and his daughter, along with the other people on the plane, all passed away. Kobe Bryant had an estate plan, but if you also recall, he and Vanessa, his wife, had just had a daughter, another daughter, and she was less than 6 months old. So what happened is Kobe had not updated his estate plan. So his youngest daughter was not a beneficiary on his estate. And so what had to happen is they had to go to court. Vanessa, his wife, and Kobe's manager, who was an executor over his estate, had to go to court to ask the court to modify after his death his plan because they said they know that he would have wanted to include his youngest daughter. And so they were able to do that. But they had to go to court to get that permission. Now, with Elvis Presley, he also had done formal planning. Recall he divided his estate up in one third to his father, who was his executor, one third to his daughter, and the other one third, I think, was to his mom. Ultimately, what happened is, of course, Elvis Presley had a very large dollar estate. But what did not happen is he didn't take advantage of advanced tax planning. So his estate, which was in, I'd have to check, multi, hundreds of millions of dollars, took a huge tax hit because of lack of advanced planning for the size of his estate. So my key here is if you're going to do estate planning, you want to make sure, number one, you keep it up to date. It is not a one and done, put it on the shelf, and hopefully it works when your family needs it. And it's not one that, based upon your estate, you don't look at again. Elvis Presley, as his estate grew over time and his success was more and more, there could have been more advanced planning. But what they all had in common is every one of these estates had to go through probate. Maybe for different reasons, but they had to go through probate. So let's talk about then, well, what is probate? So as we look at probate, we know we're going to court. First clue, probate equals court. So it is the state's plan for you. It's the way that your assets are passed to your loved ones when you die, and there is assets in your name only, meaning one owner, and that's you. And those assets do not have a beneficiary designation on it, meaning with the bank, the company, retirement, whoever it is, you have not listed with that agency where that account funds, that asset goes when you're no longer here. So what happens is, you know how when we buy a house and we buy a car, we have to sign, taking ownership of that, getting the deed or the title or whatever in our name. When you're no longer here, you can't sign that asset away to give it to your loved ones because you're no longer here. So the court process is to allow, at the end of that process, the judge to sign that final order to pass your assets. So it's really a lawsuit that is filed against you, your estate, with your money because it comes out of the assets of your estate, and it's for the benefit of your beneficiaries, your loved ones who will ultimately get it, and your creditors. Because guess what? A lot of times they're filing a claim against that estate. They're coming in and say, hey, we got a credit card bill here that wasn't paid. We need our money. Or, hey, there's a car here that wasn't paid. Or a house, something that wasn't paid. We want to get our money too. So it's a way to use your money to make sure that those people, whether it's creditors or your loved ones, get paid. And it's going through the court process. One of the things that I hear quite often, so here's debunking another myth, is, okay, I'll do a will. If I have a will, it doesn't have to go through probate. It doesn't have to go through the court. Well, what we say as estate planning attorneys is where there's a will, there's a probate. Now, what happens is that will gives the court the direction. So you're telling the court, here's who I want to be in charge, your executor or personal representative here in Florida. Here's who I want to get my stuff. And kind of here's how I want all of that managed. So you're leading the court with some directions. But the court still has to go through and, number one, make sure that will was done properly. So, for those that want to do it yourself, if you're going to do it yourself, please make sure it's done properly. Because if not, that will get tossed out and you're back into the state's plan. The court is not going according to a will that is not proper. We've heard of will challenges, someone stepping up saying, hey, I know that will says that my grandmother wanted everything to go to my cousin. Well, I think my cousin tricked my grandmother. Undue influence. I think there was some shenanigans going on, so I'm going to contest it. We're going to fight it out in court because I don't think it's right. All of that is under the purview, the guidance of the court to make sure it's right. So a will absolutely goes through probate. It's just that it gives the court the directions of what you want to have happen instead of going through the state's plan. So when we're looking at probate, most often those that have gone through probate come back and say, oh, I never want that experience again. I wouldn't want it for me taking care of my loved ones stuff. I certainly don't want it for my loved ones to have to go through that when I pass on. So some of the challenges that we see, some of the cons, is it can take quite a while to get through the probate process. Maybe 12 to 24 months, sometimes longer. I have one case now that's going on 3 years that we're trying to get through probate. And it's not a large estate. It had one house, and we're 3 years trying to get finished with probate. Assets are frozen to the heirs. So that bank account that's just in your name, one owner, and no beneficiary designation, at the time that you pass away, that bank account is frozen, meaning your loved ones cannot go get the money out of the account to help pay for, burial services, to help continue to pay the mortgage on the home while it's going through the courts, can't get money out of the bank to take care of children or anyone else. That's part of what happens through the probate process. As I mentioned, it's a higher opportunity for conflict because of will challenges. And then one of the things that is a huge con for a lot of people is that it's a public process. Our U.S. Constitution tells us that our courts are public. There are some courts that are not public, like juvenile court. But for the most part, our courts are public. So what that means is when your estate is going through probate, going through the court process, during the process and at the end, anyone can go look online in that jurisdiction and pull up what happened in your case. The petition that was filed, the asset listing, they can see that little Bobby and little Johnny, the final order says they both get $500,000. They both get the bank account, which is $100,000 each, and all of that. So now they know that little Johnny and Susie is walking out of that courthouse and they're $100,000 richer, each of them. Is that an opportunity for predators or people to take advantage? Absolutely. But these are some of the things for consideration to see if there's something you want to do different. Your kids can be at risk even if you have a will, because did you have a will and did you list who you want to be the guardian of your children when you're no longer here? Was it done properly? Was that will executed properly? Will that will be kicked out of the court, meaning is not valid? In that case, if the court don't have that valid legal document, then it's going to be up to the court to make the final decision. And sometimes that final decision is, okay, who's going to raise my children? How are they going to be taken care of? As I mentioned, for blended families, when there are stepchildren involved, if you don't put it in your will, now I won't say every jurisdiction, but most that I'm aware of, certainly in Florida, if you don't list your stepchildren in your will, they are not entitled to inherit under the state laws because that's not your bloodline. So if you want to have stepchildren or someone other than that immediate family line, it's important that you take the action to put that in your will, in your legal documents. All right, so addressing one of the things that was listed on why people don't do estate planning sometimes. Remember, they say, oh, I don't think I have enough, or it costs too much. What you will find, and if you get a chance to work with me or other attorneys like myself that kind of do this work, which we'll talk about before we end, you'll go through a process and we will help calculate what probate is likely to cost your family. And what you will find is that your family is going to pay much more in probate on the backside than what it would cost to put an estate plan in place now. So as an attorney, I do estate planning and I do probate. My probate cases, I make more off my probate cases than I do my estate planning cases. I prefer to help people do the estate planning, being proactive to do planning. Probate cases take a lot more of my time because we're going through the court process. But the fees on my probate cases are significantly more than what I get on my estate planning cases. So what I'm saying to you is your family is likely going to pay much more on the backside. So it's for you to think about, is that important to you? When a case goes through the probate process, as we talked about, your beneficiaries receive their assets outright. That's where I mentioned Susie, Bobby, whoever. At the end of the day, they are going to get money in their account. They're going to get ownership of those assets. And the way that impacts them is, that means it's not protected. It's not protected from creditors that they may have. It's not protected if they're going through a divorce. It's not protected if there's any kind of judgments against them. It's not protected for any of those things when they get it right in their hands. So I'm going to show you an alternative to this in a moment. But what I want you to kind of walk away with for probate, and there may be instances where probate may be the best pathway, but that's on a case-by-case basis. But think about, with no plan, you're looking at probate delays and the frozen accounts, possibility of high family conflict, and the possibility of losing, or your loved ones losing, what you've left for them all at once. So what can we do if we want to do some planning and we decide, I don't want my family to have to go through probate. I don't want my children to have to go through the court process to get my house in their name when I pass away. I want them to have it as simply and as easy as possible. I don't want my children to have to go through the probate process to get the bank accounts that I leave behind or any other kind of accounts that are just in my name. So one of the ways that that can be taken care of, and I'm going to touch on it very briefly because it is kind of larger, a lot of information on this, is what you may have heard, a revocable living trust. We call it an RLT. The simple explanation on this is, think of this here, this vault, kind of as your trust. What happens is we write what's called the agreement, which is actually the trust agreement that talks about what you want to have happen if you become incapacitated and when you die, what you want to have happen with your assets, who you want to get it, even when you want them to get it, and how you want them to get it. So you're writing what I call the playbook of here's the who, what, when, why, and how my loved ones will get all of my stuff when I'm no longer here. Here's how I want them taken care of. Here's the period of time I want them to receive this, because it may not be outright. It can be over years. It can be over months. And so once we put this trust together, and so when we do a trust in my office, it's about 65 to 70 pages because we're building in all kinds of protections. But once the trust is put together, we then retitle accounts out of your individual name. So it's no longer in the name of D. Sibley, it's now in the name of the D. Sibley Revocable Living Trust or the D. Sibley Living Trust. And so we put the assets in this vault here because they're no longer in my name. But while I am living and have capacity, I have full control. I can take assets out. I can put more assets in. I can change the agreement of what I want to have happen. I can change who I want to be the successor trustee, the person that's going to manage and do all of this when I'm no longer here. I can change all of that while I'm living and have capacity. But when I am incapacitated, my successor trustee is going to step in. They're going to manage all of this according to the way I say. And they're going to be taking care of me first. And when I pass, they're going to manage it for my loved ones, for the beneficiaries, according to the way I say. And this vault is basically closed. No more changes. Because the only person that can change it is the ones that set it up, the grantors. And so because the assets are no longer in your individual name when you pass away, doesn't have to go through probate. Because remember, I said probate is when you pass away and assets are in your name only and there's no beneficiary designation. So that is my simplified version of explaining a revocable living trust. When you have an opportunity to meet with me or another estate planning attorney, we can go into a lot more detail because this can be a very complex process that your attorney is going to help walk you through because there's so many decisions, there's so many options you can do with this. All right, so moving on, we've talked about how to pass assets and things like that. I'm going to touch on how to take care of yourself as we start to wrap up. So we'll look at a couple of the documents, a couple of the ways you're now looking at that first 50%, which is taking care of yourself while you're living and have capacity. The first one is, and I'll ask you again to put this in our Q&A, who has a healthcare directive? How many of you have that already in place while we go through this? And so we'll kind of talk about what it is, but I'd love to know if you have this in place already. So our healthcare directive, another name for this, is a medical power of attorney. And this is the document that says, if I can't make medical decisions for myself, for whatever reason, maybe I'm incapacitated, maybe, not conscious, but if I can't make those medical decisions for myself, here's the people that I say I want to do it for me. And here's the order in which I'm listing them. So whether it's my husband first, or my son first, or my best friend first, or my mom first, I'm telling everyone, here's who I want. So, Brittany, did we get any answers on this one?
We did. We got a good mix of yes and no.
Okay.
And we do
So
have a question though. Was that being called a healthcare proxy or is that different?
it is the same thing. You are saying a proxy is the agent that you're listing. Correct. So
Okay.
I hope if we do this webinar again, maybe with the same people in a week, the answer will be yes, everyone has one in place then, because you will take some action after this and make sure that this very important item is done. So I'm going to show you how that can look sometimes. Um, Terry Schiavo case, which was a very, very famous case here in Florida. Briefly, what happened is Terry was a 23-year-old young woman. She was married, and at the age of 23, she went into cardiac arrest. There was something that caused her to go into cardiac arrest. And over that period of time, Terry had to be fed. She had to get water and hydration through a tube. She could not eat, do anything on her own. She was basically on life support. If she didn't get that hydration and nutrition, she would not survive. Well, she didn't have a healthcare proxy, healthcare directive, medical power of attorney, whatever name you want to call it. They all mean the same thing. She didn't have that in place. So who gets to say what happens to Terry? I'm looking for answers in the Q&A. Who gets to decide? Because Terry didn't put anything in place. Anyone know?
Lots
Brittany,
of
what?
answers to this one. I'm getting a mix of the state, court, and the husband.
Good answers. So what happened is her husband wanted her taken off of the tubes. He wanted her to come off the tubes, which would ultimately result in her transitioning, her passing away. Her parents did not. They felt like as long as she's on getting that substance, getting that nutrition and hydration, there's a chance that she could come back. So they fought over that for a long period of time. In fact, it was 7 years. It went through the court process. It went all the way up to the Florida Supreme Court. In fact, the governor here in Florida got involved. Ultimately, the court made a decision. But here's what I want you to know. They made the decision based upon the testimony at trial. This had to go all the way up to trial. So it wasn't that an automatic husband was the person or an automatic parents. It was the court ruled that the husband likely knew the most recent wishes of Terry based upon the evidence that he presented at trial. He said they were a young couple again. They had talked about what they wanted their life to look like. They made plans. And during that time, she shared that she never wanted to be sustained on life support. And so the court said the husband probably had the best information of what Terry wanted to have happen. So the court ruled in his favor, and they took her off of the hydration and nutrition, and she transitioned about 7 days later. The point for this is, had Terry put that legal document in place, it would not have had to go through the court. There would not have been any second guessing about what her wishes are. So I want you to personalize this. Who is going to step forward if you're not able to speak for yourself and say what should happen? Who will step forward and possibly challenge that? Will your spouse step forward? Maybe they want one thing. Will your adult children step forward and they want something different? Will your parents step forward and want something totally different? But none of us want our family to go through a 7-year court battle, for sure. So kind of talking about that medical agent designation, the advance directive, which is also called an advanced living will, talks about how you want the end of life planning to be. So I'll give you some examples of what some of the things my clients have said. In addition to, I don't want to be on life support for an extended period of time. Sometimes I have clients that say, I will stay on life support until my adult children who live in other states can get to my bedside. Or sometimes I've had people say, I don't want anyone but my immediate family in the room if I'm transitioning. So whatever your wishes are, what's most important to you. And again, this is about making those decisions and taking that off the shoulders of your loved ones so that they don't have to wonder if they are abiding by your wishes or carry that pressure of knowing if they did the right thing. Moving forward, and I'm going to see if I can move this. So what we have here is Jay Leno. I'll talk on this one real quick. Jay Leno and his wife at this time had been married for 43 years. Jay's wife, Mavis, had dementia, and over time, her dementia progressed to advanced dementia. It came to the point where she was unable to take care of herself and make decisions for herself. So even after 43 years, what did Jay have to do? You probably guessed it. Jay had to go to court and ask the court for the legal authority to be able to take care of his wife and make the decisions for her. After 43 years of marriage, he still had to go to court to get the legal authorization to be able to take care of her business and financial affairs, her health affairs, all of that, because there was no estate planning, nothing that was put in place. That's called a conservatorship. You may be aware, Wendy Williams is in a conservatorship right now because a court somewhere has said that there's some incapacity. She's not able to make those decisions in the legal sense to be able to take care of that. That's why when we were talking about incapacity, it's not just can they think about something, can they do something under the legal definition? Do they have the mental capacity to be able to make those decisions? The HIPAA waiver here is what we're probably most familiar with. But I say, think about it. Who are the people that you are saying can be in the room when the doctor comes out and talk about how you're doing? If you don't put that in a legal document, then they typically are only going to allow in the room your immediate family. That's usually your spouse and your adult children. Some states may extend to your parents as well. But if there's anyone other than those people, then you want to have a HIPAA waiver. All right, we're going to speed along a little bit, talking about unclaimed property. It's important that your family, those closest to you, know what you have, or at least where you have accounts. You don't have to tell them how much is in there, but we don't want a bank account that maybe it might be your fund money or your travel account that nobody else knows about. Well, if you pass away, and those statements aren't coming to the house because now a lot of us are getting our statements by email and your family does not have access to your email. How do they know that you had a secret bank account at Chase Bank? If they don't know, then they can't put a claim on it through the court process. So you want to make sure that your assets are well documented, which is one of the things that we help do for my clients. So some common planning techniques. I'm going to kind of go through this last little bit pretty quickly because I do want to save some time for some Q&A. And we've kind of talked about those bank accounts. here are some of the quick takeaways that I want to give you that you can start to do right now before you even meet with that estate planning attorney to really figure out what your long-term plan is. Your short-term plan can be putting a beneficiary designation on the bank account, meaning going to the bank and saying, I want to put a payable on death on my bank account. So what that looks like is I, Sibley, go to the bank and say, I'm going to put a POD on my bank account and I'm going to list my son, Jordan. So that if I still have this bank account when I pass away, it will go to Jordan, the money that's in there. It won't be frozen by the bank so that my family can't have access to it and take care of what needs to be taken care of. And it does not have to go through probate because, as I mentioned, there's a beneficiary designation. Let me move this a little bit because I'm hiding my own screen. What I typically do not recommend, and it is case specific, is putting your adult kids as joint owners on your bank account. That can bring in a whole different set of issues. So I'll just give you two quick ones. You put your adult kids on your bank account so that it doesn't have to go to probate. And again, it doesn't have to go through probate because now is not a single account in your name. But what happens if that adult son or daughter is now going through a divorce? I know here in the state of Florida, then the courts will be looking at that bank account as, well, that's the son or daughter's bank account. It doesn't matter that mom and dad is on there. So now that's one of the assets that's going to be considered for division during that divorce. No matter who put the money in, it's owned by you and your adult son. And now if he's going through a divorce, your soon-to-be ex-daughter-in-law is getting part of that money. Same thing if that adult son gets into a fender bender and there's a judgment against him and the court says, oh, you have to pay this $10,000. It's not covered by your insurance. You can't say to the court, well, I don't have any money. The court's going to say, you have a bank account over here. Doesn't matter that it's in your name and your mother's name. You have access. Go pull that $10,000 out and pay that person whose car you just wrecked. So there are considerations. There are better options to explore when you meet with your estate planning attorney. It's not a one size fits all. So I don't think we have to talk more on this. Your family situation, your assets, your goals are specific to you. What your neighbors do on the left and your neighbors do on the right may not work for you or may not be the best option for you. I'm going to get to what I like, the kids protection plan. So our office does this, and a lot of estate planning attorneys do not, but we specifically do what's called a kids protection plan, where you get to nominate who you want to take care of your children if you're no longer here or able to take care of them. And I say nominate because the courts will have the final say. The courts always go with what's in the best interest of the child. Presumably, you're doing the same thing when you're making that nomination. You're saying, here's the person I want to raise my child if I'm unable to do it. And with our office, we have a whole book that is kind of created to give some guidance, medical information, all that, and the paperwork that gets filed with the court. Here's some examples of some kids protection planning that was not done. We probably all recognize Anna Nicole Smith. Her young daughter, she was an infant when her daughter was born. Remember the court process? Well, who's the father? So who's going to raise this child now? There was nothing done by Anna. There was no clear father known at the time, but there were a couple of people that stepped up that knew they were not the father, but said Anna would want them to raise the daughter. And so none of us would want that for our children, right? We have Heath Ledger. I think his daughter was 13 when he passed away. Her mom still alive. However, the lawsuit was the grandmother stepped in and said, I basically helped my son raise her. I've been more active in her life than her mother has. I should be the one to raise her. There is a long court battle about this between his mom and the birth mother of the daughter. There was no nomination done. So there was a long battle just based on that. And then we have Paul Walker. His daughter was almost an adult. I think she was 16 when he passed away. But the challenge was there was no nomination done, but of course, very wealthy actor. There was a pretty large account going with his daughter. So what did that mean? Quite a few people want to step up and say they should be the conservator, the guardian of this young lady. And along with whoever is going to be that guardian comes this bank account. So maybe sometimes the motives are for the best interest of the person. Maybe sometimes they're not. But you have an opportunity to put that nomination in place, considering what you want for your children. All right, as we wrap up today, again, I'm in the state of Florida. If you would like to schedule a personalized one-on-one planning session with me, which is normally $750, but you want to get on my calendar to have that session, and that session runs about 90 minutes. So it is a very personalized session looking at what you would want to do. We can certainly do that. I can refer you to attorneys in other states. And as you'll see, I think it's in here. But before I get to that, in order to talk about the things that are important to you and to see if we're even a good fit to go to that meeting, we do what's called a 15-minute discovery call. So that's where a time is scheduled where you and I get on the phone and we kind of talk about what's of interest to you. We talk about what kind of planning you may or may not want, and you may not know it at that point. But it's an opportunity for me to see if I may be able to help you and for you to see if I'm a good fit for you. If we both determine that is the case, then you would pay the $100 to get on my schedule for that 90-minute meeting. Personalized meeting where we're looking at your family, your dynamics, the things that are important to you, and really looking at a personalized plan. Now, you may be saying, I think we've already touched on this, and I won't go into that. I want to show you, we have attorneys in different states all across the U.S., and I think I have it here. This is just showing the southeastern part of the U.S. We have personal family lawyers in almost every state across the U.S. So if you're not here in Florida, I'm only licensed in Florida. I lived in New York, actually Rochester, New York, where Miss Catherine is. But if you want to meet with someone like myself, who's a personal family lawyer that really focuses on education first, informing you, educating you about estate planning, and helping you to explore your options, then you can either put your city and state in the Q&A, and Brittany will collect that information. And then if you can either put your email address, we can send you a contact in your state. May not be in your city, but certainly in your state. And all of our attorneys do a 15-minute discovery call at no cost, because that's where you will see, is this an attorney that I possibly want to work with? And that attorney can see, is this a client that I possibly want to work with and can help? If not, I know for me, if we do that discovery call, or we even go through the life and legacy planning session, and I don't feel like I can help you and you want something, then I'm going to give you a referral. Because what's most important is that you get an attorney that can help you, that you want to work with. And I think we're going to be closing up here. We are. This is my information on the screen, and then we will go to the Q&A momentarily, but that's my information and on my website, especially if you're here in Florida, would love to chat with you. Certainly email me. I do webinars all the time, do seminars in person. In fact, had one last night because estate planning is such a very vast area that it really should start with education first. Don't go into any attorney's office and they put some documents in front of you day one or even day two to sign. They don't know enough about you yet. So I encourage you, be educated, be an informed consumer. That way you know you're doing the best that you want to do for your family. And with that, I am done. And Brittany, we can open up the Q&A. If you have questions, put it there. If the question centers around personal information, then I will say, please schedule a call with me, a discovery call, because we certainly won't get into personal information here. But if it's a general question, I'd be happy to chime in.
All right, perfect. Well, I have about 11 questions, which is great. So my first one is it true that to avoid probate, that you have to have a living trust?
A living trust is a way to avoid probate if the assets are properly titled to the trust. Because remember, to avoid probate, it has to be assets that are not just in your name when you pass and that has a beneficiary designation. So when you do a living trust, part two of that is then putting the assets either in your name or making your trust the beneficiary when you pass on so that they ultimately go to the trust. So it is true if it's done properly.
Perfect. Perfect. All right. The next question is, what is a pour over will, and is it a combo of a living trust and a will?
It is not a combo. What a pour over will is when you create a trust. Remember, when you create that trust, the goal is that your family won't have to go through court, won't have to go through probate. And we were just talking about when that trust is created, then the second step is to put those assets in the name of the trust or make the trust a beneficiary. However, what if you miss one of those bank accounts somewhere and you forget to put it in your trust? That pour over will basically says to the court, where me as an attorney would go into the court and say, Your Honor, we did a trust for my client, Bobby. Bobby left off one account. He either didn't have time, forgot about it, whatever it is. So this one account is not in the trust. It's still out here. We had to go through probate. So we're asking the court to pour that asset into the trust so that it can go to whoever Bobby said according to the terms of the trust. So think of a pour over will as kind of that catch-all that when something has gotten missed, putting the assets in that revocable living trust is our way to go into the court and ask the court to pour that asset into the trust.
Perfect. Thank you. Now, this is not a seminar related, well, it is a seminar related question. Will we be sending out a link to this recording after the meeting?
I would have to get with Catherine and Liz. I typically don't because I do these so often and they change quite often. I like having the interaction, but we'll get with Catherine and Liz.
Okay. Awesome. All right, so that was that one. Sorry. My next question is, if you have a POD on your bank accounts, does that person still have to deal with probate?
No. If that payable on death, which I talked about, we call it a beneficiary designation, if the person that you've listed is alive when that POD goes into effect and they're at least 18. I don't really know any banks that's going to let you put a beneficiary on that's under 18 because guess what, you all? If they're under 18, they cannot inherit right out. So, again, when we were talking about the Anna Nicole, remember I talked about the situation where some additional people stepped up because they knew that the baby was going to inherit from Anna Nicole's estate. And if they became the guardian of this little girl, Danny Lynn, guess what comes with Danny Lynn? That whole bank account. Although if it under those circumstances, it would have been under the court supervision until she turns 18, which is another whole set of facts. But the short answer to that question is not necessarily, they don't have to go through probate as long as the beneficiary designation doesn't require.
All right, perfect. All right. My next question is, does a will outweigh a living trust?
It really depends on the circumstances. So sometimes a will may be best, sometimes a revocable living trust. Circumstances are different. Depends on what your goals are, depends on what your assets are, depends on what you want for your family, which is why we talk about this is a very personalized process. There's no absolute answer.
All right, more questions are coming in. This is great. So my next one is, and this was from an individual. They said they have a healthcare proxy, and bank accounts all have POD. When I pass, my house is already signed over to my daughter. She's also on the deed. Do I still need a trust?
Possibly. Maybe, maybe not. So when we meet, we look at all the assets. One of the things I would explore with this person is when you say your daughter is on the deed. So sometimes that can be a challenge. Remember my scenario I was talking about when you put the adult kids on as owners with you, whatever they're going through in life, that asset is going through. It's subject to that. So that would be one of the things I would look at with that person. But I can't give you a definitive answer because we don't know all the assets.
Thank you. All right, my next one is an advance directive the same as a living will?
Yes, an advanced healthcare directive it
Perfect.
is.
All right. All right. This is a pretty big one. How does divorce affect a will and living trust when each party has either the will or a living trust?
They have their individual, so that's going to be state specific. I don't have a one-time answer for that. So for that person, I encourage you, if you let us know what state you're in. You can email us at office@sibleylawpa.com. Kind of put that question in there and we'll direct you to an attorney in your state. In Florida, though, I can tell you the really quick answer is in Florida, we have something called elective share. And the short answer for that means as a married person, I cannot in my will or in my trust pretty much disinherit my husband. He's entitled to 30% of my estate when I pass away, unless he waives it. So again, that answer can be very state specific. So for the person that asked that, if you want to let us know what state, then we can direct you to an attorney that will know that state laws.
Okay, perfect. Let's see. My next one is, what is the difference between a revocable trust and an irrevocable trust?
Good question. Just what it says. Revocable, meaning you can change, modify, amend, or totally revoke it while you have mental capacity, while you have capacity, and while you are living. Irrevocable, which is set up for different reasons, means once you put it in there, it's in there, meaning your assets. So if I put my $100,000 in an irrevocable trust, I cannot get that $100,000 out. I can't change it. I can't move it around. Think about you put it in that vault and you close the lid and you turn the key. The only way to pull it out of an irrevocable is to go get the court permission. And that is not an easy job. So again, they have different purposes.
Great. The next one is a beneficiary on an account the same as a POD?
It is.
All right, cool. All right. Two more. Does a transfer on death designation affidavit on your home avoid probate?
It does if it's properly executed, and I'm going to caveat this as again, I am a Florida estate planning attorney, so I don't know for all the other states. Florida has excellent, excellent homestead protection. So in Florida, that life estate deed is what it is, does transfer to the beneficiary that you've listed on the deed at death if they are alive, of course, at that time. And of course, they have to be at least 18. But it is a way to avoid probate. And there's other benefits to it. So when I mentioned instead of putting your adult children's name on your deed, on your home, that is an alternative and has much more benefits to it. I think you said we had one more.
Two more now. All
All
right.
right.
This is
And I think we're going to have to end because
and
I don't want to overstay my welcome.
no problem. All right. So I just got this one. The state that applies to elected slash elective share, is it where you die slash reside or where you filed your marriage license?
It is where you are domicile.
All right. So where you live. All right. All right. Thank you. And this is the last one. Now, this was a specific question from an individual, but they had to drop off. Essentially, they have a job that pays over six figures. However, any persons working in their state that are Medicaid clients on long-term disability programs are restricted to 40K. Is there an estate plan that allows you to take anything over 400K and to protect it from taxes, Medicaid, and put it aside for only medical needs, devices, education, etc.?
Oh.
I know that was a
So
very
I think
specific one.
it
So,
is. So that would be one I want to talk to them about, but it sounds like what they're referencing is one of those irrevocable trusts we were talking about.
mhm.
One type of irrevocable trust is something we call the Medicaid Asset Protection Trust. And it is a way to protect your assets for your beneficiaries in life and to take it to get it out of your estate so that when you apply for and receive government assistance down the road, you don't have to spend or um, use up all of those assets to qualify for those government benefits.
Okay.
But again, that is an irrevocable trust. And there is something called a 5-year look back period. So it's getting very specific. But it just know that there's a 60-month requirement. It's a way to put assets aside so that they go to your children. You don't have to spend down those assets in order to qualify for Medicaid or government assistance. Okay.
Great. That was
All right, you
the last of the
all
questions.
awesome. So, Liz, Catherine, I thank you so much for the opportunity to come and share with your audience here today. It has been an absolute pleasure. I am just always just so passionate about sharing information about estate planning because it's so, so very important. And I think the more we can educate on this topic, the more people are comfortable with exploring the best options for them. So I thank you for this opportunity.
Thank you all for, yes, Catherine for setting up, and Dee and Brittany, thank you so much for being here. It's been great. I do just want to share real quickly, Marilyn Sibley, who is the Tri-State Chapter Chair, just wanted to say great presentation, and she really appreciates you being here. So I just wanted to share that on behalf of Marilyn as well. So thank you so much. I don't know if you have anything, Catherine, but that's it for today.
Well, I think that both of you did a wonderful job. Thank you, Brittany, for handling the Q&A. You did a great job. The presentation had so many practical insights and expert guidance that I know will help anyone who attended to make some smart decisions about their estate for themselves and their families. So, there's nothing more important than that. So thank you so much. And thank you to everyone who has attended. We really appreciate that.
Have a good afternoon.
Bye bye.
Thank you,
Bye bye.
everyone.
Bye. Take
Bye.
care.